I know that you mentioned at the beginning that you wrote the LSAG update, specifically the section on technology. I think that's section 7. There's obviously quite a large part of the guidance that's dedicated to this to add much more clarity around it. Yeah. So can you tell us your thoughts on, firstly, the use of technology for AML and compliance, and also your thoughts around open banking and using technology as part of the CDD or source of funds process? So that's kind of a two-parter, if you like.
Sure, okay. I'll tackle the first one first, if I may. That's the general technology on AML compliance. So let me state very clearly, I'm absolutely in favour of the use of technology where it makes compliance more effective, efficient, and simpler for practitioners. In my time in this role, I'd become aware that solicitors and firms were somewhat confused by the technology on offer, unsure how it could help them or would help them, what it actually did, and how secure, safe it really was. Many firms either avoided it completely as they weren't confident in it, or perhaps ran some sort of check, stuck it on file, and thought, okay, jobs are good and that's my AML sorted. Well, the latter scenario actually there is arguably a lot more risky. The use of technology is increasingly viewed as robust, secure, sophisticated, and in many situations may in fact be lower risk than traditional means in some circumstances. All that said, firms need solid guidance on the technology out there, what it does, how it can help, but importantly, the advantages and limitations of such technology in AML compliance. I guess that was the premise and the starting point for the new technology section, that's section 8 in the guidance, and what it aims to achieve. And very quickly, a few quick back to basics thoughts on AML technology, if I may. It's really important that firms understand what the system does and what its limitations are. Firms should document in their AML policies and procedures what the firm uses the system for and in what circumstances. You need to ensure you put sensible data in to get sensible outputs. And you must know what the outputs are actually telling you and what then to do with those outputs. And you must record the outputs and what decisions and actions were taken on the back of them. In terms of open banking, okay, so open banking technology can absolutely help and support firms in undertaking source of funds and source of wealth checks by helping clarify and efficiently categorizing credits and debits into and out of the client's bank account. It may be, however, that open banking can't help firms really understand the origins of the funds, as I've said previously. It's also for the practitioner to then make sense of that information in the context of the matter at hand, ask questions of the client using the data provided by open banking as a basis for those questions, and then corroborate or evidence the information provided as necessary given the level of risk inherent in the transaction. So it would never be enough simply to do an open banking check and leave it at that, but certainly open banking is certainly a useful tool to help firms in their AML compliance.